I'm going to bring in my think tank tonight. Joining me here in studio, we have with us criminal defense attorney Ray Giudice, Assistant Chief Jailer Lieutenant Colonel Adam Lee, and criminal defense attorney Rachel Kaufman. Welcome to you all. We have one more guest joining us out in San Diego, great criminal defense attorney out there. Vic Bajaj joins us in San Diego, and he'll be with us in just a moment. So let's start here. Lieutenant Colonel, you just heard what Chanley said. This man allegedly in the room at the time of the rape, not interviewed, not investigated by prosecutors. Are you surprised with that?
Yes, I'm horribly surprised because he has to be complicit in some way if there was a crime that took place. And he should have been on the radar for sure to answer some questions.
Absolutely. And Ray, this is a guy who, according to the accuser, is participating, and then she testified that he's the one that ends it all. Once she says no, stop, he's the one that stops it.
Big advantage to the defense and this witness never coming in a courtroom. First of all the things that Ms. Painter just told us about subpoenas and private attorneys, the jury's never going to hear about that. What's going to happen in the defense closing argument is they're going to write his name up on a blackboard and say, where was he? Where have 100 witnesses plus the state calls? All the power of the state to subpoena a witness and bring him in. The marshals are standing here. Go get him, prosecutor. Bring him in. Let's hear the truth. Big advantage to the defense.
Are you surprised that he did not show up in court?
I'm very surprised that he didn't show up in court, but I think it's really important, just like you were saying, that the defense is going to be able to say if the state wanted to not just validate, but instead verify the facts of each of the Jane Doe stories, that they would try to get as many witnesses that they knew were actually there to verify whether or not what the alleged victim is saying is actually true.
All right, I want to go out to San Diego. Vic Bajaj, criminal defense attorney, joining us. Vic, thanks so much for being with us tonight. We're talking about Matt Vaughn, who is the third person who is inside the room at the time of the alleged attack, not investigated, and does not testify for either side here. What's going on?
Well, if you're looking at this from Mr. Vaughn's point of view, it's an impossibility to actually testify. You are going to be damaged either way. If you testify on behalf of the prosecution, well, the prosecution itself would never want to call Vaughn because Vaughn would have to deny the sexual conduct that Jane Doe is alleging occurred in this situation. He would have to. Otherwise, he'd be walking himself right into a conspiracy for a sexual assault, the same charge that Mr. Winslow Jr. is defending him against himself against now. On the other hand, you have to understand that anyone who understands the consequences of coming into court, a live court case that has a ton of media, it can't be good. Once it says Mr. Vaughn on the TV, when many people don't listen to the words that may come out of our mouths, the association of an individual with this type of conduct is something that can never balance out on an opportunity cost. And of course, let's not forget that he is well within his rights not to testify, even if he was subpoenaed, because he has a Fifth Amendment right against self-incrimination. Now, the way to get around that, if we follow that road just a little bit farther down the line, the district attorney's office or any prosecutorial agency throughout the U.S., we see this, has an option. Well, Mr. Vaughn, I can give you immunity. Tell me what you have to say. I will give you immunity. You will never face criminal charges. Just tell us the truth about what Mr. Winslow Jr. said. And that's something the prosecution likewise will shoot themselves in the foot if they do that, because the question then becomes, how can you let someone who is so intimately involved in such horrendous allegations walk just to get testimony against Mr. Winslow Jr.? So getting his testimony and securing it, in my opinion, from the get-go has just really been a fallacy. I don't think that's a possibility.
Ray, all right, I want to play a hypothetical here. It didn't happen. That night with Jane Doe number 4 never happened. Matt was never in that room. Does that change the equation here on whether the defense should call him? Should find out where he is, track him down, do whatever you have to do, slap a subpoena on him?
No, I wouldn't take the risk. I think So many points have been scored by him not coming. I think the immunity issue is excellent. That was just pointed out, that the defense it's the old where are the fingerprints argument. Here's a live witness. I might pull out the phone book and say, hey, he's living at 335 San Bernardino Way. Why come the prosecution never called him? I think it's a great argument for the defense. And as again pointed out, how come he didn't get charged? She says he's doing about the same thing. It's a sexual assault either way.
Lieutenant Colonel, as an investigator, don't you want to find out as much as you can about an alleged rape? And that's why I don't understand why prosecutors didn't follow up, track him down, and interview him, just to find out more.
They certainly should have. I think we might be looking at a situation here where we don't know who this guy is now. He may be a corporate person now who's afraid of ruining a reputation that he's built his life. We don't know what his family is like. All those things I'm sure he's probably having to think about before putting himself in a situation where he's going to make national news and just be put on camera and people possibly talking negatively about him, and it could possibly ruin his life. Like I said, we don't know who he is and how important he is to the community that he lives in.
Could be something we don't know.
Right.
Maybe he's an undercover for the local gendarmes.
Right.
Maybe he's got a couple felonies pending against him, or he's going to roll on somebody.
Or
Don't
he's
forget-
100% innocent and a pillar of the community, and this
Absolutely.
never happened,
But
too.
there's something out there. But again, these kind of questions are what? They make 12 jurors debate this issue. And boy, on the defense, I want 3 over here and 3 over here and whatever the number left in the middle, kind of taking sides and swapping, and I hope I hear them yelling that guy's name in the middle of their deliberations.
I want to play one more part of the testimony of Jane Doe number 4, again, as it relates to this Matt, who she says was in the room at the time. Again, this is back in 2003. Take a listen.
After he flipped you onto your back, were you lying on the bed?
Yes.
Had you been telling him no during this time?
Yes.
After Matt got up and you heard him tell Kellen to stop, is that when Kellen flipped you onto your back?
Yes.
What happened after he did that?
I kept telling him to stop, and then I turned my head to the left. Because somebody was there holding a camera.
Based on your best memory, do you recall seeing somebody holding a camera inside the bedroom when this happened?
What I initially came to, no.
So now there's also, according to Jane Doe number 4, someone in there with a camera. With a camera. Rachel, there's been no evidence of any video or still photography or anything from that night other than one photo of Jane Doe number 4 with Kellen Winslow in the car earlier in the evening. But what does the jury do with this mysterious camera that may have been in the room?
Well, they're going to do what they want with it. So I think, as a defense attorney, what I like to say is that it's easier for the state to connect the dots when there's fewer dots. So if you don't put up the witness, if you don't verify things with the camera that actually tells the truth, it's easier to persuade a jury that this was the truth and that you should believe her. So I think that's what's going on, and I think it's just going to depend on how jurors want to perceive the evidence. If they're looking for proof, obviously there's not enough proof. But if you just want to believe someone, one witness is enough.
You can believe them.
Yeah,
Vic,
so.
how does all this impact the jury? The fact that there's someone else in the room, there's a camera in the room, yet none of that now is part of the physical evidence in this case or testimonial evidence from these other people.
Well, number one, I don't think there's enough of a foundation for everyone to actually believe that there was a camera or a video recorder at the time. We have a statement that was somewhat flippant. Maybe it happened. I did remember it. But there's no actual evidence that this data can actually be assumed or acquired by anyone. But let me tell you this. In our state and all states around the union, one thing is consistent, okay? That is, if you have evidence, you still don't have an obligation to bring it, okay? And that is, you cannot assume it doesn't exist by it not being presented, but at the same time, the jurors are going to be given an instruction that says, if a person that has, or the party that has the ability to produce the evidence doesn't produce it, you can make implications in that regard. I think this issue on the videotape or the audio tape or the snapshots are irrelevant. It's a sideshow. I think it also lends a lot of credibility to the theory that this case has moved along too quickly. And let's talk about that for a second, because now we're in jury trial roughly a year after these allegations came about. Now, in this jurisdiction, having tried cases here and around the nation, I will tell you that that's very rare and that's odd. And so you have to believe that there was a strategic decision down the line, maybe based upon other DNA or forensic evidence that people did not want to come about, perhaps, that made this case push along so quickly. And there are some real deficits, and dare I say this as a member of the bar here in San Diego regarding my fellows, may I say that there's some evidence that should have been presented, an investigation that should have been done, such as the fencing.
We're going to get to that in just a second, Vic.
That should have been
Vic,
presented much earlier.
It's like you're producing my show tonight. We're going to get to that fencing. We're going to talk a lot about that. Coming up also, folks, we're going to take you live outside the courthouse where Kellen Winslow II's trial is wrapping up.